I am, here we go. So just to reiterate, Ashley Bargainquest, the president of your Contra Costa County Bar Association Criminal Law Section. And I'm very excited to have everyone here today. Cris Lamb is going to be presenting on Beyond Humphries, where we go from here because the fight isn't over. This is going to be the criminal law section's last MCLE event for 2021. And it's also the last webinar other than the MCLE Spectac that the Contra Costa County Bar Association has for this year. So thank you so much for joining us. I am also excited about what we are going to get to do next year as this world continues to change, and I will be sending out some information about that in the upcoming months. If you have any suggestions, interest in being on the executive panel, or any other concerns or suggestions, I am very open to them and very interested in hearing from you. If you have not had the absolute pleasure of being educated by Cris Lamb before, you are in for a treat. And if you have had the opportunity, you're still in for a treat. Some excellent background on people who haven't attended her panels before. Cris was actually my first trial mentor when I was in law school, and it is always so exquisite to be taught anything by her. You may have caught her in the Carmen Miranda method of cross-examination, and if not, please look up that link because it's very good. So without further ado, I will turn it over to Cris and take it away. You're still muted, Cris.
Sorry, got it. Okay. Hi, everybody. Thanks for coming. I wanted to talk to you about where we go from Humphries. And I apologize, I just got back from a long vacation, so I was jammed and I didn't get my materials done in time. But what I am going to do is to send them by the end of the week to Ashley, and she will make them available to everybody. Essentially, the issue is that I've done different motions at different points in time in litigation, and I'm attempting to put it all together so that it's relevant for right here and right now. So let's talk about Humphries. Humphries is a strange opinion, in my opinion, because it seems to ignore its own, the California Supreme seemed to ignore its own previous rulings in different cases. So, well, the good news is that it says that money bail is not appropriate in most cases, and they have to take into account a defendant's ability to pay in setting monetary bail. The bad news is it talks a bunch of crap about public safety, and it doesn't really answer a lot of questions. And here is why it's really an issue. So I wanted to talk about, just a second, I printed it out. Let me just find it. I wanted to talk about the issues that are left open, and also how to get around some of the things in Humphries. Okay, so Humphries talks about Prop on page, let's see. So just for everybody's edification, in re Humphrey is, the citation is 11 Cal 5th, 135. And it was issued by the California Supreme Court on March 25th of this year. On page 135, looks like 152, they start talking about how Proposition 9 on the November 4th, 2008 election amended the California Constitution to allow for public safety, etc., in setting monetary bail or conditions of bail. Okay, well, what's the problem? The problem is in a case called People versus Standish, that's Standish, and that citation is 38 Cal 4th, 858. That was decided by the California Supreme Court on June 5th of 2006. They point blank state at pages 874 through 875 that Article 1, Section 28 did not go into effect. The reason why is because there was a competing measure on that same ballot. Both of them passed, but the competing measure, which is Article 1, Section 12, got more votes. And they were contradictory and not complementary, so they cannot be harmonized. And Standish says that point blank. So in Humphries, they have revived these public safety arguments. And on page that I just said, which was, I think, 152, they stated that that was done by Proposition 9. No. Proposition 9, if you pull it up, sought to amend Article 1, Section 28, which Standish point blank says was never operative. So the argument would be that you cannot amend a section that the California Supreme Court said is not operative, and for the reasons stated in Standish. So my argument is that the public safety it just isn't in effect, and the language and reasoning in Standish still applies. And let me further talk about the issues that are still left open by Humphries. And that is, they seem to acknowledge that clear and convincing evidence is needed in order to detain someone in the very narrow circumstances that are allowed by Article 1, Section 12. And in Standish, they even specifically state that that Article 1, Section 12 requires specificity, not just some amorphous public safety. And therein lies the real issue, because Article 1, Section 28 does have this kind of risk of harm, possible risk of harm in it, where Article 1, Section 12 does not. So you need to really stand firm and say Article 1, Section 12 is what is operative, and point blank, the California Supreme Court seems to not be aware of its own precedents, because it stands to reason if Article 1, Section 28 was never operative, that an amendment, a Proposition 9 to amend it would also not be operative, because an amendment to an inoperative section of the Constitution, you can't just revive it that way. Okay, so what is left for us to push? Several things. One, we need to be pushing for actual evidentiary hearings. And in the materials that I will be sending you, I have briefed the standard of clear and convincing. I've also briefed the fact that police reports are not admissible in the state of California. In fact, they are even exempted out from FOIA, or not FOIA, California Public Records Act requests. There's a government code that exempts them out. They are not public record. They are not official records, because the information contained in them is not by officials who have a duty to report accurately and correctly. They're police reports from people on the street and witnesses that have no such duty. Furthermore, Penal Code 1204.5 states that a police report cannot be argued without either the defense agreement and consent, and then it has this kind of amorphous or in conjunction with a bail determination or hearing. I think that we need to push the fact that police reports are, one, not official records, they're not business records, they're not public records, they are inadmissible. So a DA who has no personal knowledge, just getting up and spouting the facts of the police report, cannot be clear and convincing evidence. So please note that what the DAs are arguing is, or citing to, is in re White for the proposition of clear and convincing evidence. And in that case, the things to remember are, one, in re White, the detention without bail was made after an evidentiary hearing. That point seems to be just lost on everybody. It states right in the beginning that this determination was made after a preliminary hearing. One where the defense was able to cross-examine, put on evidence if they wished, etc. And the other thing to remember is that it was an abuse of discretion standard, and that's a whole different ballgame. So we have those two things. It should not stand for the proposition of some amorphous risk of harm, but please know that this case is out there. The DAs are going to cite it. In re White, here are the facts. Two guys hanging out in Southern California at the beach. And one of them is watching girls and making comments about, raping them. The guy that he was with, white, he didn't know well, they were just hanging out. Anyway, they end up following the girl, and I believe it was the other guy's car, to her home. And the other guy, not white, attacked this teenager and attempted to rape her. Both were charged. White was charged essentially under an aiding and abetting, essentially for being a lookout. White had no previous criminal history, and the court nevertheless detained him without bail, citing that the fact that he was willing to help this guy, even though the evidence was, speculative on that, and act as the lookout. And it was completely random and such a horrible crime that the judge believed that he was a public safety risk to other random girls. So we really need to hit this clear and convincing standard with case law and arguments, because I think it just is rational that clear and convincing evidence can't be just mere statements parroted from the police report from a DA who was not present and doesn't know anything about the accuracy, and usually by that stage in the proceedings have really done no investigation. Okay, so let's talk about strategy. Prior to Humphries being decided, many of you probably know that Humphries came out of my office. I'm with the San Francisco Public Defender's Office. And prior to that ruling, we were just randomly litigating the bail issue. I had a case called James Ring, and he had prior strikes. He was charged with another strike offense, as well as gun possession and first-degree burglary. And I did a bail motion, and that didn't go anywhere. And writted it up, and neither the Court of Appeal or the California Supreme Court heard the writ. So I went to federal court. I don't know if this is the only time that this has occurred in the state of California, but the federal court here in San Francisco issued an order to the San Francisco Superior Court to let James go. In the materials that I will send you, I will include the petition for federal review in James. Now, why is this where the game is at? I think because I'm not sure how many of you are aware or have ever read a Ninth Circuit case called United States versus Scott. That citation is 450 Fed 3rd 863. It was published June 9th of 2006. Judge Kaczynski issued the ruling. It's an extraordinary decision. Let me tell you what the facts were. A guy in Nevada, under Nevada state statutes, was charged with felony drug possession. And in order to get out of custody, they routinely required that defendants sign away their right to search and seizure, and agree to random drug testing for anybody who was busted with drugs. So Scott got out. He signed these consent forms, an actual form. And the police, based on this waiver, search and seizure waiver, went and searched his house while he was pending trial. And lo and behold, they found illegal firearms. And then he was charged in federal court for the firearm possession. In federal court, his defender brought a motion to suppress, and it was granted. The prosecution sought review, and it went up to the Ninth Circuit, and the Scott opinion came down. So in the Scott opinion, Judge Kaczynski brings up some arguments that we need to be making, especially since we're going to make sure that we're arguing on federal grounds. Judge Kaczynski analyzes the consent search waiver 3 different ways. And there is a doctrine that all of us should be aware of and should be pushing in federal court, and that is the unconstitutional conditions doctrine. And that states, and this would be on page, hang on a second. Why is it so hard to always tell where the pages are? It looks like it's on page 866. The unconstitutional conditions doctrine states that the government's ability to exact waivers of rights, of constitutional rights, as a condition of benefits, even when those benefits are fully discretionary, is limited. And it analyzes it under that and states that nope, it violates this doctrine. And then Kaczynski, and there's great language, you should really get to know what this doctrine is and start pushing this. Then he analyzes it under the consent, whether it was actually valid consent. And then he analyzes it under just a reasonableness of Fourth Amendment, because that's the gravamen of the Fourth Amendment, it must be reasonable. And he finds that it was not reasonable under the Fourth Amendment, and there's great language in there about why. And upholds the motion to suppress. So what this tells us is, one, we should be bringing motions to suppress whenever our clients are busted on new cases based on especially pretrial search and seizure conditions. 2, Judge Kaczynski brings up In re York. In re York is also cited in Humphries. For those of you who are not familiar with In re York, that citation is 9 Cal 4th 1133. It was decided in 1995 by the California Supreme Court. And that was the seminal case in California that allowed courts to impose search and seizure as a condition of pretrial release. Judge Kaczynski brings up In re York and states that he does not believe that that case would hold constitutional muster after several cases, which he cites in the opinion, were issued by the US Supreme Court. Anyway, the really important stuff in this decision is that Kaczynski states that one, you cannot, it would be impermissibly and unconstitutional, one, to presume somebody is guilty for pretrial release. That's a big one. And he also states that he says that a presumption of innocence can only imply innocence, never guilt. The other thing that he takes on was the other conditions that were placed on Mr. Scott, and which were not really implicated in the search and seizure motion. And that was the random drug testing. And Kaczynski stated that the prosecution did not put on any evidence to show that someone who is randomly drug tested is more likely to show up in court. And he clearly states that that would be required. So he also states in this, that he kind of implies that the Eighth Amendment applies, although the Supreme Court has never held that. That's the other thing that we need to be pushing. And I believe it's the only amendment left that the Supreme Court has not held to apply to the states via the 14th Amendment. But there would be no good argument for not applying it to the states. And I would use the language of Judge Kaczynski because there's some great language in here. So what this decision tells us is, one, bring suppression motions, even when you think it's based on consent. And two, you want to be pushing this opinion, although the California courts have just ignored this opinion. This opinion has been out for almost 16 years now. But the fact is, it's settled law in the Ninth Circuit. And if you petition to get your bail matter heard in a federal district court, especially if you're practicing in COCO, then the federal district court is going to be bound by this decision. So what happened after the Scott opinion is that there was a request to have the opinion heard en banc, and that was denied. So obviously the government wasn't very happy, but they lost, and the Supreme Court, the US Supreme Court, ostensibly would be aware of this opinion, especially because the Ninth Circuit was kind of the bad boy that they always took pleasure in reversing, and this opinion stands. And the federal courts, if you can get your bail matters heard in front of them, are going to be, or at least the Ninth Circuit and California courts are going to be bound by this decision. So sorry. The other thing that I wanted to The other thing I wanted to tell everybody, I'm not sure who does and doesn't know this, but as of January 1st, 2022, there's good news on the horizon. There is a new law that is going into effect, and I forget the number of the bill, but the governor did sign it, and that is prohibiting in most instances and greatly taking away the court's ability to hold a person who is being violated on probation or mandatory supervision on no bail. That is going to be a thing of the past. In other words, when your client is on probation and the district attorney files a petition to violate that probation, typically, especially in most counties, on felonies, they just automatically summarily revoke and hold them on a no bail status. That will no longer be the law as of January 1st. So we want to be arguing that the Humphries decision, at least the good parts of it, about indigency and setting bail within a person's means, would apply to our clients when bail is set on a probation violation as well.
Quick Google search on that, Chris, indicated that it's Assembly Bill 1228. I am going to put the link in the chat.
Thank you. And again, I'm so sorry I didn't get my materials done in time, but I will absolutely get them done and forward them to everyone. So the other thing I wanted to talk about, and in the end notes as well as in the body of Humphries, they mention Penal Code 1270.2. And I'll just tell you how I use it here in San Francisco, and then Mano, the public defender here, urged the rest of the office to also use it. So typically we do that. 1270.2 states that after arraignment, the original setting of bail at arraignment, if for, quote, want of bail, in other words, if your client can't make that bail, your client has an automatic right to a review of that bail decision within 5 calendar days, not court days, calendar days. And the language states unless the defendant waives that right. So I've been arguing that, one, the courts should have been doing this all along automatically, or procuring waivers from a defendant because it appears mandatory and not permissive unless the defendant waives that right. So how I used it here and we're using it here is if we, go to arraignment and we don't like the bail decision, we automatically set a 1270.2 within 5 calendar days. The point is to be a fly in the ointment and to teach the courts that if they're not going to be reasonable in their release or bail decisions, then we will jam up the courts. And that's a real issue, especially during COVID here in San Francisco, because we really never opened fully up. So we have a backlog of cases, and the courts will quickly get it. And strangely enough, it's successful in probably about 80% of the cases. It also gives you a little bit more time to, one, talk to your client's family or get more information about resources or alternative measures to confinement to inform the court on at the 1270.2 hearing. Okay, so police reports. Okay. I urge you also to actually read Article 1, Section 12, and Humphries again. Humphries actually states in the back notes that they are, hang on a second. A couple of times in the Humphries opinion, the court states, we're not deciding this today, it's not before us, or whatever. Those are the things that we need to make sure are in our motions, that we put these very issues right before them and go for it. And one is, does our client have the right to an evidentiary hearing, and how on earth could it be clear and convincing evidence if that were not the case? And two, we need to hold the courts very specifically to the language in Article 1, Section 12, which I have printed out. Just a moment. Which states, a person shall be released, that's mandatory language, on bail by sufficient sureties except for capital crimes, and note, when the facts are evident or the presumption great. Or B, felony offenses involving acts of violence, sexual assault, when the facts are evident or the presumption great, and the court finds, based upon clear and convincing evidence, that there is a substantial likelihood the person's release would result in great bodily harm to others. In the Standish opinion, the Supreme Court makes clear that that needs to be specific, not just a possibility. In other words, who's going to be harmed and why? And then the second C, sub C, is felony offenses when the facts are evident or the presumption great, and the court finds, based on clear and convincing evidence, that the person has threatened another with great bodily harm, and there is a substantial likelihood that the person would carry out the threat if released. So we want to make sure that the court really hits these standards. I don't know about you, but here in San Francisco, the courts are still spouting public safety without specifying. And there are even some judges who are considering just recidivism for garden variety property crimes to be a public safety risk. And I would argue that that's not what public safety means in Article 1, Section 12. It's very specific. And at the end of Article 1, Section 12, it says excessive bail may not be required. In fixing the amount of bail, the court shall take into consideration the seriousness of the offense charged, the criminal record, and the probability of his or her appearing at trial or the hearing of the case. And then it ends with, a person may be released on his or her own recognizance in the court's discretion. In other words, even if the people show B or C, the court still can OR someone. And even if it's a capital crime, Article 1, Section 12 still gives the court discretion to OR someone. That's very different than Article 1, Section 28, which has this kind of nebulous risk of harm. But you do want to take the language in the cases that I cited, and let me give you a full list. And again, I will get them written down and sent out to Ashley. But it's United States versus Scott, 9th Circuit, 450 Fed 3rd, 863. You want to take a look at In re York, which is 9 Cal 4th, 1133. I've already given you the citation for Humphrey, but I'll give it to you again. In re Humphrey, 11 Cal 5th, 135. People versus Standish, 38 Cal 4th, 858. And In re White, and that's 9 Cal 5th, 455. Sorry. Sorry about that. The other very troubling thing in Humphrey is that in dicta, they state that for purposes of bail, we presume that the charges are true. There was a group that petitioned the court requesting that they depublish that portion of the opinion because, one, it was never briefed, it was never argued. And there is already a brief on this, and I can't remember if it's John Scott Hamilton or Michael Kennedy of CPDA, which briefed why that's incorrect. And in fact, Humphries does cite these two like 1890s or whatever opinions, but either, I can't remember if it was John Scott or Mike Kennedy, pointed out why that is an incorrect statement. It happened that they just picked up the language when the reason that they had to presume guilt at that stage was because it was on appeal. It's a completely different thing. And the reasons stated in the Scott opinion about why we can't assume guilt, that is unconstitutional, should be used in your briefs. So where's the next fight at? Okay. In a few minutes, I'll open it up and maybe we can talk about what your different experiences are, but let's get back to James Ream. Okay, so the federal court here issued a ruling to the San Francisco Superior Court that they had to let my client go. They had to release him. And what happened was, as you can imagine, the judges here were not very happy at the federal court telling them what to do. And so what they did is they released James, but they loaded him up with such ridiculous conditions that he violated, I want to say, about 6 weeks out. And they were very joyful when they just put him back in custody. And what the conditions were is they had him, and remember, he was homeless, he didn't have a phone. And the date that he got released, I remember it was really cold and it was raining. And they made conditions of release that he have to drug test, go to different drug counseling, and report in person to our pretrial services on a daily basis, as well as call him by the phone. Anyway, when he got out, I took him and I got him a burner phone, at least to, give him some resources. And he did everything that he was supposed to, even under those conditions, except he had a dirty pee test. And he always came to court, and they just gleefully put him back in custody, up you to the federal courts. Well, that seems to be how a lot of courts are proceeding on with Humphries is, okay, well, we'll just set, a gazillion conditions that, we haven't shown have any bearing on helping him come to court or ensuring that he's in court. And as soon as he violates, we're going to say, okay, we've done it, and just take him into custody and hold him in custody on unreasonable bail. That appears to be how, if they're doing it in San Francisco, I can just imagine what they're doing in Sacramento or Fresno. So that's why we need to take the language in the cases that I've given you and really start requiring that there is some evidence that any of these conditions have any bearing on ensuring that somebody comes to court, or any bearing on another permissible reason. For instance, the way that I read these cases, without all of the huge mistakes, is that they're limited under Article 1, Section 12 to when there has been a credible threat, and or there is specific evidence to show that specific people or the general public is at risk, and to show why that is, rather than just some speculation. So I would even suggest, one, we need to push for evidentiary hearings. And if they won't do that, consider finding academics and get them either to, or get their publications that would at least show some evidence that there's no correlation between attending AA and making sure that somebody goes to court, etc. So what the Scott court said is that they would have to show in the drug condition that one, it has to be very individualized for each specific defendant. I would take it from what the opinion says is they would have to show that Mr. Scott has a little problem getting to court because he's high on drugs. And absent that showing, that random drug testing would bear no correlation to making sure that he comes to court. So, sorry if this missing. So we need to be tackling these conditions and making sure that they comport with the federal law that is applicable in our jurisdiction. Always be making this on federal objection grounds that are in these opinions that I've given you. And I would also argue to, object on Article 1, Section 12 when it applies, and point out that the California Supreme Court states in the end of Humphries that we haven't really decided, it's not really in front of us this time, what portions of 12 and 28 apply, or if they can be harmonized. The problem is they really have already made that statement, and at least didn't address it in Humphries that Prop 9 was amending an article that they said was never implemented, never went into effect. Hang on a second, I'm trying to. So the other thing that I'm starting here in San Francisco, and I would urge you to do that maybe through your bar association, or if you're with a firm, and or if you're with the public defender's office, start doing this as well. So what we are going to start doing, which was my idea, is to keep a database on every case where the DA argued for detention without bail and the court granted it, and then they made a probation offer, or the case was dismissed or won at trial. So we are keeping a database where we can pull it out, case names, case numbers by judge, by DA, and when we have amassed enough information, we will be explicitly putting that in our motions against detention motions to detain without bail. Anyway, I wanted to open it up if there were any questions or requests. Let me see.
I think this is always the hardest part of webinars, is that we can't give you a round of applause right here because there's so much good information here. I know I have a bunch of questions. I haven't seen any pop up in the chats yet, but you began to address one of them, Cris, when you were talking about the how it's being handled, that presumption of the charges being true when setting bail, because that has always struck me as just a blatant violation of the presumption of innocence, but it is regularly cited from the bench. If you search it in case law, it's regularly there. It seems particularly true, after an information is filed, but is generally used when setting bail at any point. The judge will say, well, counsel, I have to assume that these charges are true when setting bail. So,
I mean, basically, the federal court says, in the Ninth Circuit says, no, a presumption of innocence can only give rise to a presumption of innocence. Now, I know the courts love to say, oh, the Ninth Circuit or the federal courts aren't binding. However, the case law clearly says they are to be given great weight, particularly on federal questions. So we are going to make sure that everything is on federal grounds. And also, I'll see, I'm sure that I have I'm sure I have the briefing that points out historically why the courts kept picking up on that language when it was just, again, a lack of scholarly thinking. And then they've just repeated it so often. So, and, you know, I love it when they say that they are not bound by the federal courts on questions of federal law, but we can make them be bound. And we can do that by taking our issues beyond the state courts. So I would suggest that get an agreement in your county who is going to do this, who will take this on and do this. And I also wanted to state before I forget, so essentially it would be habeas. And a lot of people also don't know that there is a judicial council habeas form. And it must be accepted in a superior court. And so obviously you have to start or should start your habeas in superior court. But what I'm trying to tell you is you can just fill out this JV form and staple your points and authorities, and you don't have to worry about formatting and all of that crap in superior court form, and it is good. Then when it's denied, you do have to do the correct format in the Court of Appeal. But what I've done previously is one, if the Superior Court sits on it and doesn't really do anything, or just denies it or whatever, and then I have a little bit of a trail of this, because every court does have original jurisdiction for writs. It's just preferred. But I have gone and passed that and just said, you know what, the reason why I'm going directly to the Court of Appeal or whatever is because in this case, the Superior Court already decided it's the same issue, or they won't issue a timely decision. There are no time limits for decisions on writs. And that was another thing that did happen to me in Sacramento, because I used to file habeas on the bail issue years ago in Sacramento. And they just simply sat on it and did nothing. And then I decided, okay, well, you know, I'm just going to go straight to the Court of Appeal and say why I'm doing that, in that the Superior Court refuses to issue a ruling on these or you know, do anything of it in a timely manner.
Absolutely. If we can get you and I can talk to make sure that habeas form, that judicial council form, is included in all the materials, so everyone just has it. I know everyone, we've opened it up since it's a small intimate group, that if you want to unmute yourself and ask Cris any questions, I don't want to take all the question time, but I do have another one if nobody else does. I was wondering, with the 1270.2, it's an automatic review within those 5 days. If they don't grant you that hearing, right? If you don't get your review thereof, it doesn't look like there's a remedy in the code section. So what's the remedy if they violate it?
If they violate it, I would writ that up. The reason why is because it's mandatory. It's even cited in Humphries, Humphries went up on habeas after a 1270.2, okay?
Yeah.
And they cite that. They even cite in the opinion that it is a mandatory review. And we did have one judge here say, I'm not going to do that. And it wasn't my case, so I'm not sure if we writted it up. But I would write it up, and I would also consider a complaint, because the California Handbook on Judicial Conduct states that it's a beautiful, it says there are no more fragile rights than those of the indigent accused. Therefore, judges must scrupulously protect and honor them. I would use that quote, and also there's other great stuff in that book. A judge can be wrong on rulings, evidentiary rulings, and all of that until the cows come home. What they can't do is refuse to abide by the law, and that they can be disciplined for. So I would argue in the complaint that there's nothing ambiguous about the statute. It is mandatory language, and it is even referred to by the California Supreme Court in 2021 as being good to go, that this judge is refusing to abide by the law and scrupulously honoring the rights of the indigent accused.
Okay. And it's one of those that so often when it doesn't say right in the code section what the remedy is, we do have to writ it, right? But
well, what I will say is that when I started this here in San Francisco, and I did it in Sacramento as well, judges had never heard of it. And they grabbed the code section, they're like, and there was some pushback, and one judge said, well, why would I change my mind in 5 days? And I'm like, take that up with the legislature. They thought that, but in fact, judges more often than not did. I can't really say why that is. One, because you may have more information. Sometimes, at least in this county, because the DA who argued for it didn't want to come into court 5 days later, so somebody else is handling the case who doesn't know jack shit about it, and so they have somebody else beating on their chest. I'm not sure why judges do change their minds, but that has been my experience. But most judges have never heard of 1270.2. They don't know that it's mandatory, and they don't realize it's 5 calendar days. This has the potential to really jam up people's courtrooms.
What's so interesting is it is that automatic review, right? So technically, the defendant shouldn't even have to request it. So
that's what I argue. I said, look, you should be aware of this. We are all charged with knowing the law, and you should either be automatically doing this or asking for a waiver.
Yeah,
it's
taking a waiver.
Right. And so I don't know why judges weren't aware of it. I really don't know. And especially after Humphries, you would think that every judge in the state had read it, because it twice it refers to 1270.2.
Yeah.
And like I said, we did have one judge here who just refused to abide by it. Now, the other thing that judges did here is they were like, well, when will you have your papers filed? And I'm like, oh no, I am not required to file anything. This is a mandatory review of your decision. Where in the statute does it say that unless the defendant, a written request or points and authorities? So what I had a tendency to do would be do the 1270.2 at arraignment. And then, I mean, if they, either put stupid conditions or wouldn't release him or put him no bail or held him on unreasonable bail, whatever. And then maintained the 10-day no waiver, and then actually bring a written bail motion at the preliminary hearing, after the preliminary hearing, because that's the other time. So basically, it's my way of gumming up the works as many ways as possible.
Well, it's all non-frivolous litigation. If the choice was made and the ruling was made at the beginning that didn't need to be advocated zealously, therefore, there would be no need for the paperwork. We're at about 1:15 now, and I know some people have to head back to court, including yourself, I believe, Cris. So this is where I'm going to give you a big old round of applause, and thank you so much for coming. And I'll let everybody know that I'll be sure to get out all of the materials from Cris to everyone. As she indicated, there are different pleadings. We'll make sure to get those judicial forms. The specific pin sites are regular sites for all the cases done so that we can really start bringing this.
All right. Thanks.
Thank you, Cris.
Thank you so much.